Hi, I'm David Marchant, the founder of OffshoreAlert, which investigates participants in high-value cross-border finance with an emphasis on high-confidentiality jurisdictions. Our specialty is exposing investment fraud while it's in progress. Enjoy our content.
Good evening, ladies and gentlemen. My name is Howard Sharp. I'm based in the Jersey Channel Islands, and I'm delighted to chair this session entitled Alternative Methods to Recover Assets as part of this year's OffshoreAlert conference. I'm going to invite the expert panel members who join me in this session to talk to you about the growing influence of private prosecutions in the United Kingdom, and also discuss whether and how civil fraud claims with the usual freezing, search and related disclosure orders can run in tandem with an ongoing prosecution. And so if I may, I'd like to introduce my two panel members to you all, both of whom are very experienced lawyers. I start with Tamlyn Edmonds, who's a founding partner at the London law firm Edmonds, Marshall, McMahon. The law firm are private prosecution specialists and are described in the Legal 500 as a firm with unsparing attention to detail and the very model of how fraud cases should be prosecuted. Tamlyn also listed in Legal 500 as a lawyer who cuts through complex issues quickly, efficiently and accurately. Mr. Jonathan Tickner is the head of commercial litigation and civil fraud at another London law firm, Peters and Peters, who are described in the Legal 500 as a go-to firm for civil fraud work. Jonathan is widely praised in a number of directories, including Who's Who Legal, for his civil asset recovery practice and wealth of experience in this area of law. In terms of structure of this 45-minute session, I'm proposing to break it down into three broad parts. In part one, in a moment, I'm going to invite Tamlyn to start perhaps by speaking a little about her experiences of private prosecutions. In part two, I'm then going to invite Jonathan perhaps to provide an overview as to a high-profile art fraud case that made a lot of media headlines during the course of this year that featured both civil fraud claims and a prosecution with considerable overlap. And in part three, finally, we will have a more general discussion about the possible interplays that can occur when a prosecution and civil claim in fraud are running in tandem, and to look out for what sort of issues might arise and what a party might need to be wary of. So starting with part one, perhaps Tamlyn, I could invite you to just help us with your experiences of private prosecutions, and perhaps, if you don't mind me asking, perhaps you could just describe what is a private prosecution and why would someone want to or even need to bring a private prosecution?
Sure. So a private prosecution is basically any prosecution that isn't brought by the Crown or any other statutory prosecuting authority. So, for example, the SFO. The UK is one of the only few jurisdictions in the world that allow private prosecutions to take place and be brought by victims of crime in the criminal courts without having to rely on the state to do so. So any individual, any company, any NGO, charity, any organisation can bring a private prosecution. And the right to do so is preserved by Section 6(1) of the Prosecution of Offences Act. They're certainly increasing in numbers over the last few years. They are increasingly brought by corporates and individuals, and they're often described as a constitutional right against inertia or partiality on the part of authorities. In terms of why someone would want to bring a private prosecution, There are a number of reasons. The main one is due to the lack of resources in traditional law enforcement authorities, certainly in the UK. Police and other investigating agencies have faced enormous cuts over the last few years. Since 2009, the police have had a 14% reduction in numbers, which means that certain types of offences, so particularly fraud and economic crime, is no longer the priority of the police. And the SFO also concentrating on large corporate crime, which means that certain types of crime then fall through the net. So what we are finding with victims is they're reporting a matter to the police, certainly in relation to fraud cases, only to be told that they don't have the resources to investigate, or that they are advised it's a civil matter, whereas when we review the case, there is clear evidence of criminality, or it lands on the desk of an officer who does not have experience of investigating financial crime. We also find that in relation to cross-border fraud, we have victims who are unable to get any particular jurisdiction to take that on. And as long as a relevant event of that offending has occurred within the jurisdiction of England or Wales, then we would have the jurisdiction then to prosecute that here.
I see.
Sorry, Harry.
No, carry on. Sorry, I interrupted you.
Would you like? I can talk through some examples of the types of cases that are regularly brought. As I said, most of them are fraud related. So we bring private prosecutions for investment frauds, money laundering cases, internal fraud committed by employees on behalf of corporates, conspiracies to defraud, and also perverting the course of justice charges, where false statements are often made in other proceedings. So that can be brought by way of a private prosecution. There are certain types of offences that do require consent from either the director of the SFO or the DPP. So, for example, bribery requires consent. But fraud is not an offence that requires consent. So you can bring a private prosecution for fraud. And if I can give you an example of a cross-border fraud that we've prosecuted, is the case of Kasanov against Mr. Kulik. So Mr. Kasanov was a Kazakh businessman who had a number of insurance and reinsurance businesses in Kazakhstan. He wanted to set up companies and bank accounts outside of Kazakhstan, particularly in the UK and Hong Kong. And he was introduced to a gentleman called Mr. Kulik, who was a Russian national living in the UK. And he was introduced to Mr. Kulik as somebody who had an expertise in company formation and tax. And so he paid Mr. Kulik an agency fee to set up companies for him and bank accounts in Hong Kong. That agency fee was paid into Mr. Kulik's account in the UK. And Mr. Kulik then asked Mr. Kasanov to travel to Hong Kong to set up a bank account with Standard Chartered Bank, which is exactly what he did. He traveled to Hong Kong and was told to go to the Bank of China building to what he thought was a Standard Chartered office. It turns out it's a very sophisticated fraud. So the fraudsters had actually hired an office within the Bank of China building and set it up to look like a Standard Chartered bank. So it had Standard Chartered logos. He went into the bank and met with what he thought was a Standard Chartered bank manager. He was given some forms to fill out in order to open up a bank account, which he did. But unbeknown to him, the account had already been set up in the name of the fraudsters. So he returns to Kazakhstan And in the post, he is sent a banking device to log in to internet banking, which he does, and is faced with what we later found out was a fake banking portal, which he thought was a legitimate Standard Chartered banking portal. So he promptly transfers over $2 million into that account. He then shortly finds out that he cannot access the account any longer. And he contacts Mr. Kulik to find out what on earth is going on. Mr. Kulik stalls him by saying, Standard Chartered suspect you of money laundering, so they've frozen the account. We need to get evidence from you of exactly what this account is for. So it's all a stalling tactic for the funds to then be dissipated from the account. Mr. Casanova then gets suspicious. He travels to Hong Kong. He visits Standard Chartered's head office, and he is told, yes, the account is set up, but it's not in your name and there are no funds there. So he reports the matter to the Hong Kong authorities, and he is told that they cannot investigate because the defendant lives in the UK, so they don't have jurisdiction. So he travels to the UK, he reports it here, and he's told that the UK police don't have the resources. And again, because most of the offending happened in Hong Kong, he was encouraged to go back to Hong Kong and report it there. So he was in a situation where he's left with no alternative other than to pursue a private prosecution here in the UK, which is what he did. We got a Norwich Pharma Court order against Standard Chartered in Hong Kong to disclose all of the banking material, and he pursued a private prosecution here. Mr. Kulik was convicted and is currently serving a 5-year prison sentence.
Can I ask you, off the back of that, how does it, in terms of a private prosecution, is it possible to achieve asset recovery, assuming a conviction?
Yes, it is. A private prosecutor can take part in what's called confiscation proceedings under the Proceeds of Crime Act. Proceeds of Crime Act is draconian legislation. It is there to effectively deprive a defendant from the proceeds of their crime. So where a defendant has been convicted of an offence of which they've financially benefited from, then the court can make a confiscation order and a private prosecutor can take part in those proceedings. It's a valuable tool in the fight against fraud, against fraudsters. One thing, certainly in my experience as a prosecutor, most fraudsters don't mind serving a custodial sentence, but they do mind when it comes to their assets. So POCA is a valuable tool. One of the benefits of confiscation is that if the defendant does not pay the confiscation order within a set time laid down by the court, there are custodial sentences imposed for non-payment, and they are statutory time limits. So anything over 1 million, a defendant could find themselves serving an additional prison sentence of up to 14 years on top of their original sentence. So it's an incentive for them to pay. One of the things with confiscation is that any confiscation receipts go back to the state, not the private prosecutor. But the private prosecutor can ask the court to make a compensation order at the same time as the confiscation order to compensate them for the loss that they've suffered. And then that is enforced in exactly the same way as a confiscation order. And sorry, Howard,
No, I was just going to say, so in a case like the one you've described, where the state is refusing for whatever reason to prosecute the case, the person who's been defrauded can come to someone like you, bring a private prosecution, and assuming they achieve conviction in the course of the criminal proceedings, they then have the options of applying to the criminal court for either a confiscation order or even a compensation order with a view to recovering that which they've been defrauded of. Is that a fair
yeah, Exactly, and most will apply for a confiscation order and a restraint order to prevent the defendant from dissipating their assets. A private prosecutor can only apply for a restraint order upon charge. They cannot do it during the investigation stage.
I was going to ask you if you saw any risks of the private prosecution route in general terms.
Yes, there are a number of risks. The first is the risk of the Director of Public Prosecutions taking over the private prosecution and discontinuing it, where they're of the view that it doesn't meet the Code for Crown Prosecutors test. So there are two stages to the test. Is there sufficient evidence to provide a realistic prospect of conviction? And is it in the public interest? If that test is not met, then the DPP can take over and stop it. Another risk is that of disclosure. A private prosecutor does have to comply with disclosure obligations in exactly the same way as a public prosecutor. So that would mean that any unused material, so any material that is relevant to the offence gathered in the course of the investigation, has to be recorded and retained, and if it undermines the prosecution case, must be disclosed to the defendant, or if it assists the defendant, that also has to be disclosed. If a private prosecutor gets that wrong, then there could potentially be cost risks if the case is dismissed as an abusive process.
So the risk is the case might be dismissed as an abuse regardless of the merits of the prosecution, in terms of the strength of the evidence against the defendant.
If there are disclosure failings, if there are serious disclosure failings, then it could be dismissed as an abusive process.
Yes, I see. Thank you, Tamlyn. Is there anything else you wanted to say by way of sort of overview and introduction before perhaps I invited Jonathan to speak about perhaps his art fraud case?
In terms of overview, it's just that private prosecutions now are a very valuable tool in the fight against frauds, and are increasing in number.
I see. Thank you. Okay, well, I'll come back to you shortly. Jonathan, there's been an art fraud case that sort of traversed the globe at times this year and has hit the media headlines. Perhaps you could be kind enough to give us a bit of an overview and summarise the various civil claims and indeed prosecution that's taken place, all surrounding the same individual who seems to have caused some considerable difficulties for quite a large number of people.
Yes. Well, thank you, Howard. So yes, I'm following on from sort of Tamlyn's a very helpful summary of the benefits of private prosecution. I just wanted to focus, as you say, on a specific asset recovery case, civil asset recovery case, which I've been involved in over the past 12 months. And that does focus on the rather opaque and clandestine art market. So if I could just start maybe with Andy Warhol's comment, where he said, making money is art and good business is the best art. And in the context of the current art market, I mean, his words have never resonated with more truth. So the art market itself, I mean, just by way of background, 2018 was valued at approximately 67 billion, and the sector's become a rather profitable playground for the rich, but also vulnerable to exploitation by fraudsters. Now, art fraud is a sort of umbrella term and can sort of encapsulate a broad array of wrongs. It could be some type of false representation made in order to make a financial gain, and that can relate to either the artwork, its age, its provenance. We all know, obviously, have read about forgeries, but scams, and the one that I wanted to talk about in relation to Mr. Philbrick, also involve the reselling of shares in art. And so where you've got here investment in art, you've got a general culture of secrecy over private collections and bids and so on. But what you also have is people buying shares in artworks. And those shares mean that sort of beneficial ownership can be hidden. And this makes it very easy for criminals to sort of employ scams where they resell single artworks to numerous buyers, or oversell fractional ownership of pieces of artwork or shares in artwork. So this was the kind of case that we wanted to talk about in relation to Mr. Philbrick. He was a US national, is a US national. He was a high-profile art dealer in London. He had galleries in London and Miami. Amongst one of his victims, I mean, he has several victims because effectively he was operating a Ponzi scheme internationally, was a German-based art investment company who I acted for, who have launched a civil legal action in around November 2019 in relation to various works which they acquired from Mr. Philbrick. And one of them was a very well-known piece. It's Rudolf Stingel's portrait of Picasso. Now, they purchased this for around $7 million for this Stingel painting on Mr. Philbrick's advice. And what they did was that they effectively bought a dominant share in the artwork. So it was sort of 80% share of this artwork, and Mr. Philbrick would retain 20%. And this was all documented. It was subject to German law in relation to the contracts and German jurisdiction. And what Mr. Philbrick would effectively do, and he didn't just do this for this particular investment company, he did it for all sorts of other investors, and they're very high profile. You only have to Google his name, you can see who the other victims are. He would source these items to be purchased, and often he would say, look, they're very undervalued, we can make a turn on this painting, we can buy it for X, sell it for Y in 2 years, and I will sort of massage the market and get people interested in this particular artist. And in this case, the German finance company contributed most of the funds. The work was purchased, and then it was on the basis that Philbrick would hold the painting, the artwork, for a few years. He'd then sell it on for a profit, and then the profits would be divided between the parties pro rata. So this was supposed to be the plan in relation to the Stingel painting, and as with a number of other artworks that were acquired in a similar manner. Crucially, physical possession was always retained by Philbrick. He was very keen to ensure that he, as the dealer, he would keep the painting. He obviously had storage facilities. It was all insured. Now, the trigger for this victim finding out that there was the fraud is that it was agreed that this painting would be auctioned at Christie's in New York with a minimum guarantee of $9 million. And there was a security that the auction house provided, but they would buy the lot if it sold for less than the guaranteed sum. That is what the German investment company thought was going to happen. And in fact, what happened in practice is that the artwork was sold for just over $6.5 million, and that triggered a sort of realization that this wasn't going according to plan. And Christie's refused to pay the guarantee on the grounds that actually what Philbrick had done was forge a guarantee certificate in the name of Christie's, but actually Christie's had never given the guarantee. It was passed on to my clients, but it was a forgery. And also, they were not recorded as the legal owners of the painting. In fact, actually, the painting had been sold on behalf of other investors. So this was the fraud. And the fraud at its heart is that Philbrick was alleged to have sold single artworks many times over to different buyers, and to have fractionally sold pieces, amassing more than 100% for any given work. So, as I say, it was an art Ponzi scheme, defrauding very wealthy investors. So when the sort of realization dawned and investigations were carried out, what happened there was that in the High Court in London, we applied and obtained a worldwide freezing order against Philbrick personally and against his corporate entities. And that applied for moving any assets outside the jurisdiction. Now, it was a Section 25 application, Section 25 of the Civil Jurisdiction and Judgment Act, because actually the main claim would have to be brought in Germany. So because the contracts were subject to German law and jurisdiction, but the English courts were able to effectively demonstrate a sort of long-arm jurisdiction. They were able to grant a freezing order in support of the German proceedings, effectively in aid of foreign proceedings. And similarly, lawyers in Miami at around the same time, again on behalf of the same clients, got asset forfeiture proceedings started in Miami. Now, the story is that Philbrick effectively went on the run, and he was arrested in June of 2020, so June this year, by US law enforcement agencies, who discovered him hiding out in the Pacific island of Vanuatu. I can't pronounce it. Howard, I think you have better pronunciation than I do.
I'm not sure. I think it's Vanuatu, but I could be wrong.
Vanuatu is absolutely right. And the following month in July, he was indicted by a US grand jury on charges including aggravated identity theft and wire fraud, and crimes, effectively, which if he's found guilty, he can carry a maximum combined sentence of up to 22 years. And I think quite sort of famously, the US attorney for the Southern District of New York, Jeffrey Berman, said in a press release, "You can't sell more than 100% ownership in a single piece of art," which of course Philbrick allegedly did, together with all his other scams. So I mean that is all in a nutshell is sort of the case, and obviously assets are still being searched for. I mean, Philbrick is sitting in a cell somewhere in New York, subject to obviously COVID restrictions, but there are a number of other proceedings that are ongoing, and obviously there is the criminal process which will run in parallel. But I think that what I think was important here was that victims were able to move very quickly, as we've discussed, to sort of get worldwide freezing orders. And similarly, in this kind of case, Norwich Pharmacal orders can be obtained against auction houses, art storage companies, and in the other associated parties that may have knowledge of where assets might be stored. And obviously, in this case, the sort of criminal side was sort of catching up. After the civil victims had taken their own civil asset recovery steps.
Am I right in thinking that Mr. Philbrick is alleged to have also used a number of pieces of art belonging to other people as collateral for a loan for his own personal benefit? Is that one of the central allegations he's facing?
That is exactly right. So, I mean, he was effectively dealing with the same pieces of art, but using it to either as collateral for other investments. But effectively, he had a finite number of artworks that he was buying, but he was using it as collateral for other investors or for his own purposes. Exactly right.
Yes. I mean, one of the attempts to trace assets came to Jersey this year, and one of the art owners who felt with good grounds to think that they had been defrauded by Mr. Philbrick came to Jersey because they had instructed a private investigator who felt that they had gathered some information which pointed towards possibly a hidden bank account in Jersey, prompted some consideration as to whether Norwich Pharmacal or freezing orders should be obtained in Jersey, and we dealt with that earlier this year. And it raised interesting issues as to how much quality information a private investigator can produce in the first instance, and what to do if the information that's being provided is either incomplete or one can't be completely sure how much confidence you can have in the information that's being put forward. Did you want to say anything about that, Jonathan?
Well, I suppose the only thing really to say is one of sort of that lawyers who practice in this field and investigators I think, have to be very careful, because, I mean, well, clients could often believe, or victims of fraud could often believe what they want to believe.
Yeah.
And I think in that sense, they're vulnerable to having been exploited by the fraudsters. They're vulnerable to being exploited by professionals who can over promise. And you know, in your example, there is an investigator who has effectively either overpromised or gone further in actually stating that intelligence is true when it isn't, and I think that it's a real, it can be a real issue in our work.
And I suppose it introduces conflicting dynamics, because, as you say, the client is understandably upset for good reason. Mm-hmm. Understandably wants to recover what are in any view significant financial losses, and therefore emotionally wants to get into court at the soonest opportunity for fear of dissipation of assets if they don't. And on the other hand, particularly I suppose in civil fraud proceedings, when you're first starting, you may well be bringing an ex parte application where the bank or the defendant isn't there, and you have that duty of candor to reveal all information to the court that might undermine the strength of your application. And there's a potential tension there if you're being given partial information only as to what it is you might be looking for in a particular jurisdiction.
Indeed. And of course, the other point to make, I suppose, is that in the sort of common law jurisdictions where you're applying for freezing injunctions and you're doing so ex parte, there is a duty of full and frank disclosure, and there's also a duty to go with clean hands. And so you do have to explain where information has come from. Often, you know, that requires you having a very close relationship with investigators to ensure that information which they have obtained has been obtained properly and lawfully. Because, of course, if it hasn't, you need to tell the court. You need to be upfront with the court. You can't pull the wool over the court's eyes, otherwise that's going to come and bite you. And I mean, that's a slightly different point, I think, to the one that we're making, but in a way, it's the source of that information and its veracity is so important.
Yes. Okay, well, thank you very much for that, Jonathan. I think we might move on to part 3 of our discussion now, and perhaps talk about what happens if you've got let's take an example of a private prosecution that's been started because a victim's gone to the police. They've said they can't help because they don't have the resources. So they've decided to start a private prosecution. They've also decided to start civil proceedings somewhere almost in parallel or in tandem with the private prosecution. Tamlyn, can I come back to you, perhaps to start with this sort of stage of our discussion? What are are there typical issues that one has to be careful about if you've got those 2 sets of proceedings running in parallel?
Yes, definitely. So there's nothing to prevent them running in parallel, but there are a number of potential risks that you need to be alive to. Certainly, as a private prosecutor, you should not bring a private prosecution for the purpose of just applying pressure to somebody in civil proceedings in order to get them to settle. So the court will be carefully monitoring the motive of the private prosecutor in bringing that case. It's very important when starting proceedings, which you do by laying an information at a magistrate's court, that you have the duty of full and frank disclosure at that stage, and that the court is informed of any ongoing civil proceedings in full. And again, you have to put your defense hat on as a prosecutor at that time and consider what the defense would be saying if they were there. So if there are ongoing civil proceedings, that does need to be disclosed. The criminal courts are alive to mixed motives of private prosecutors. So they will be aware that a private prosecutor's motivation won't necessarily be purely for the public interest. There will be mixed motives there. But as long as the motivation isn't completely unrelated to the proceedings, and as I said, just to apply pressure on a defendant in civil proceedings, that potentially could amount to an abusive process. So that is one risk. Another risk, which I'm sure Jonathan will expand on, is the collateral use of documents. So where you have to be incredibly careful that you have the consent to use documents gathered in one set of proceedings. If there are documents disclosed in the civil proceedings and you want to use those documents in the criminal, you have to be sure that you've got the relevant permission from the court in order to be able to use those. So those are a couple of risks from the private prosecutor's side.
Can I just go back to your first point for a moment? So in terms of making sure you're not abusing the prosecution process. Yeah. Supposing you do have a prosecution running, you have a civil case running. Let's suppose the civil case settles unexpectedly, just settles. What do you do with the prosecution in those circumstances? Is there any public duty to carry on with it, or can you bring that to a conclusion as well, or does it just depend?
It's case specific. I would say it is incredibly difficult to extricate yourself from criminal proceedings once they are up and running. And any private prosecutor does have to be alive to that from the beginning. If the case settles in the civil court, that does not automatically mean that a prosecution will be stopped. So again, it is case specific. And a private prosecutor does have to be warned of that in the beginning.
So a client may need to understand that if they are going to commence a private prosecution, that they may need to understand that they have to commit to it regardless of any other settlement outside those proceedings.
Yeah, absolutely. They need to be alive to that at the beginning. Yeah. There are instances, certainly with other cases and the CPS, where if civil proceedings have settled, then you do consider whether it is in the public interest to still continue. That is part of the Code for Crown Prosecutors test. But a client has to be warned in advance that does not automatically mean that criminal proceedings will stop.
Oh. Jonathan, do you want to come in on the Tamlyn's point about the collateral use and the use of documents that have been provided for a purpose in certain proceedings?
Yes, thank you. Well, I mean, coming from a commercial civil litigator's perspective, there are obviously restrictions on use of documents which have been disclosed in civil proceedings for any other purpose. And as Tamlyn says, and the exceptions are if that document has been disclosed by the other side, when I say the other side, let's say you're acting for the claimant here. So in a private prosecution, you'll be acting for the victim. That victim is also a claimant in civil proceedings if there are parallel criminal and civil proceedings. So if the defendant is compelled to disclose documents as a result of being a defendant in civil proceedings, those documents can't be used for any other purpose. And the exceptions are if that document's been read out in open court. If it's been read out in open court, effectively it loses its sort of confidentiality, and in that sense, it's sort of free to be used in any other claim, but or for any other purpose. But there are therefore restrictions if it hasn't been read out in open court, and you would have to get the consent of the civil court, so that will require application to be made, and that application would have to include an explanation to the judge as to why you wanted to use it for any other purpose. And civil judges may not grant. It would be discretionary if there were objections there to collateral use by the defendant. The judge may not grant it for all sorts of reasons, not least, as Tamlyn says. Actually, I think the civil courts, there is a reticence when you have private, and this I'm sort of pulling back here and making a more of a bigger point, I think, which I think needs to be made, is I think civil judges, and Tamlyn can sort of speak to how the criminal judges will react, but I think civil judges will be innately conservative animals, and to that extent, I think that they don't like the idea of sort of this kind of parallel pressure being brought to bear by victims through sort of parallel civil and criminal proceedings. I think that's very different if the police or the Crown are bringing the claim, because that is an independent. But effectively, when you've got a private prosecution, really it's the victim. I know that Tamlyn can talk about the fact that you've got the prosecutor is supposedly independent, but effectively the prosecutor is a lawyer for a private law firm who's being paid by the victim who's funding this. And similarly, that same victim could be funding lawyers in another law firm, or even potentially in the same law firm. I think that's very tricky, but in another law firm to pursue civil fraud proceedings. And I think any judge faced with this kind of application, we want this document, it's really important in the civil, it to be used in the criminal proceedings, will say, well, wait a second, this is either under pressure or it's oppressive, and so on. So I think you have to be very careful. I think really having parallel private prosecution and civil proceedings, I think would have to be exceptional circumstances to sort of justify that happening. I don't know whether Tamlyn has a view on that.
Yeah, I mean, I certainly do not think it is automatic in every case. We have run private prosecutions alongside civil proceedings, and in those instances where we have had to apply for documents in the civil courts, and normally it is banking evidence, then permission has been granted in those cases. There was clear evidence of criminality and in the public interest that the investigation of crime and prosecution of crime is pursued. But as Jonathan said, it's not an automatic position. And I do think courts are always alive to the risks.
Tamlyn, is there any statistical data? This is a question that's coming from the chat rooms. Is there any data as to the success rates of private prosecutions when compared to ordinary prosecutions, if you'll forgive the analogy?
No, the Ministry of Justice, who's responsible for keeping records of prosecutions, they don't differentiate between private prosecutions and public prosecutions. When a private prosecution is brought, it starts off in the name of the victim or whoever's bringing the private prosecution. But once it is sent to the Crown Court in fraud cases, it's then brought in the name of the Crown. So it effectively falls away. So there is no separate statistical data taken on private prosecutions and their success or otherwise.
Is it fair to say, though, that those bringing private prosecutions have normally got the resources to pay for quality lawyers, quality investigator, quality advocate, which they may or may not have got had they gone the normal public route?
Yeah, for the most part, they are resource intensive, and often victims will have those resources to throw at the case to ensure that it's properly prepared and properly conducted, and they have the right legal team on board.
Yeah. Jonathan, I was just going to ask you, do you, as a civil practitioner, do you feel that the civil fraud route offers better and broader powers of obtaining relevant evidence, or do you not think there's very much in it?
No, I'm very biased. I think if you can go down the civil fraud route, and often you can't, in which case I think the private prosecution offers huge advantages. But if you can, then yes, I think there are more immediate remedies and emergency orders that can be obtained, as it were, before you've even issued your claim. So that will include Norwich Pharmacal, going to banks, getting disclosure, getting search orders, and the like, which aren't available in a private prosecution. and therefore evidence can be secured and so on. I think that gives it sort of the trump card in terms of moving if you can. But I think often in cases, civil fraud cases, you can't move. Often you don't have the jurisdiction, or for whatever reason, there may be reasons why civil proceedings can't be brought. And I think that in those circumstances, the private prosecution is a really a very good option.
Right. I can thank you very much, Jonathan. I can see we've got 19 seconds left, so I'm going to just simply say thank you to you both very much for giving up your time to speak to everyone this evening. Thank you also to everyone who's joined us. Enjoy the rest of the conference, and good evening to you all. Thank you.
Thank you.
Thank you.
Thanks for watching. Consider subscribing to our investigative news and documents service and attending our events. For more information, visit offshorealert.com.